So 12 days after the video was posted, the Law Society issued a Section 45 certificate against me and Artem, and they declared us unfit to practice law. That was done pretty much by ambush. No hearing, no notice, no charges, no tribunal. And as lawyers, we know that that could never be the process. But that's what the legal regulator has done. The Law Society of New South Wales, the Professional Standards Department, and the Law Council has done. And this was signed off by Miss Valerie Griswold, the very person on the first prompt notice that we gave that she had engaged in unlawful corrupt conduct. We even gave her notice to recuse herself on the matter, and that she had fabricated findings of misconduct and prior misconduct, which she stated not as an allegation, but as a statement of fact that it exists. She even tried to get admissions from us that there was misconduct, and also gave us an option to withdraw our renewal application, which means to effectively cease being practicing lawyers. So very first notice, as soon as we received their correspondences in July 2024, we already gave them notice that you're doing unlawful corrupt conduct. What's even more disturbing is that they used their office to sit there, watch the YouTube video, my 10-minute long video. They screenshotted my YouTube video and they transcribed it. And then without any notice or ever putting it to me, they just attached it to their decision with a public notice. That's an online post on my firm's website. And that was also not put to me. So all these things that was attached to the decision on the 30th of May was something that I just found out when they made that decision that I'm not fit. So they made sure that they deprived me any opportunity to defend myself and to answer. And this also applied to Artem. So this was very targeted. And as I said in my previous video, they just justified that it's a targeted discriminatory act. And it doesn't matter what we do, what evidence we put to them, what law, and we shouldn't be telling them the law because they know it like the back of their hand. They are making annual reports to the Parliament about the disciplinary proceedings, and they're fully aware of the Uniform Law, Chapter 5, and they report on it. There's a big interest here. So even though their decision actually stated that there's no disciplinary proceedings or findings against us, that means there's no legal case against us. And what would be logic is that the only option under the Uniform Law, if you look at their flowchart, which I will put up, is that they can only close the case. But of course they couldn't do that with us because they have an agenda. They needed to take us out of the legal profession. What you've just witnessed is a state of lawlessness. And yes, this is happening in our legal sector. Help us bring light to this pressing issue. Like, share, comment, and I'll be posting more videos. For more information, visit our website at tojanbrylllawyers.com.au. Read our call for action to Premier Mins, New South Wales Premier. Sign our petition, and if you want to donate, we have also set up a GoFundMe for those who want to donate and support our cause. Help us protect the rule of law and the public.